Hello, I'm Lyn McLean, Director of EMR Australia, and it's my privilege this afternoon to be talking to Ray Broomhall, who is known to a lot of you. He is a barrister in law who specialises in the issue of electromagnetic radiation. He's from Michael Kirby Chambers, and he was recently on the 5G International Summit where he was giving his legal perspective. So, Ray, thank you very much for joining us. And I have some questions for you.
Thank you for having me, Lyn. It's a real pleasure. Thank you.
That's good. Now, today, Ray, we're talking about businesses and the legal implications of running a business in the digital era. So my first question to you is, do businesses have a legal responsibility to provide a safe workplace for their staff?
Yes, well, I guess when you look at what workplace safety really is about, it's that everyone has the right to a healthy and safe workplace. That means that your employer must make sure that the workplace is safe and without risk of harm to health. So it also means that a worker also must take care in the same vein and to make sure that their practices don't harm themselves and also their co-workers. So when you look at it, there's a huge responsibility, and yes, they have a legal responsibility to ensure that occurs. Yes, particularly under various legislation and laws, etc. But and workplace health and safety acts are a very good example of that. And the courts like to instill those obligations in regards to ensure that there is no risk and that their practices do not pose any risk to their workers.
Okay.
Mm-hmm. Is that, yeah.
That's great. Thank you, Ray. It's interesting that you're saying that they have a legal responsibility, but at the same time, what we see nowadays is that most businesses are exposing their staff to radio frequency radiation. If we just talk about radiation and not the other fields, and it could come from wireless access points, from wireless routers, from modems, from wireless computers and laptops, mobile phones, wireless keyboards, wireless mice. There are lots of sources in the average business, and that's what we see, more and more sources when we go in to do testing. So the International Agency for Research on Cancer has classified this radiation as a Class 2B carcinogen. So here we have this potentially carcinogenic emissions inside most businesses. So how does that fit in with this concept of having a safe workplace? And do you think that there could be problems for workers being exposed to this radiation?
Well, very much so. You raised the issue in regards to the International Agency for Research on Cancer. Now, there's two things that they've done. One is that in 2002, was a study done on magnetic fields, and they found that if children, for example, are exposed to anything over 0.3 of a microtesla in the home, which is a magnetic field, that there is a consistent association between that and childhood leukemia. So that then prompted the WHO, the International Agency for Research on Cancer, and also ICNIRP to acknowledge that there is a real risk of harm. This is for non-ionising electromagnetic radiation. And so they then, in 2002, classed magnetic fields as a Class 2B possible carcinogen. Now, what was really interesting is that also in 2011, they sent out another communique basically saying very clearly that RF fields are also possible carcinogenic. So you've got both the magnetic fields and the RF fields. So, and I guess the issue here is that when is it safe? And I guess you will see things where they're talking about saying that there are no adverse health effects. Well, for example, the International Agency on Research on Cancer says that there are, and that's why they're saying there's a possible risk. The WHO has acknowledged that. ICNIRP are not really I guess you could say, a government body. They're more an advisory thing. They're not really accepted as an authority as such. But the issue here is that I guess you could say that the best way to explain this is that you have an organisation called the APANSA, which is safety standards, which are set by APANSA. Well, that's not merely an industry point of view. They're not medical, they're not health. Where I focus my work and where the industry sort of doesn't understand is that there is also health standards. The health standard that we have is what's called the International Classification of Diseases, which is produced by the WHO, the World Health Organization, and it's called the ICD-10. Now with the ICD-10, what we have is here where doctors use this standard to diagnose and treat patients throughout the world, and Australia has adopted that standard, and that is the medical side of things. Now what's very clear under the W90 of the ICD-10 says that exposure to non-ionising radiation, particularly radio frequency, is an adverse health effect. So when they're turning around and saying it's not, the medical profession saying it is, science is saying it's not, which one do we follow? Now the interesting thing here is that we follow, and this is how I've been using that and utilising that, is that the health impacts are basically from doctors, not from scientists. It's as simple as that. So if I guess you could say that access points such as wireless routers, etc., and then we're starting, as 5G is starting to kick in, we're starting to wear more wearables that employers have to insist that their workers wear. They're going to start getting into wireless power transfer systems where they don't actually have the wall, that they're charged wirelessly. So with wireless power transfer, so as everybody understands, is that 5G is about sending not only data, but also sending wireless power through the air, or electricity through the air. Hence our magnetic fields are going to increase, and we have a real problem. Now, what I would like to explain too, so as you have a bit of an understanding, is I'd like to share a document from I've got a PowerPoint here, which is an extremely interesting document. And what I'll do is hopefully you can see this.
Yes.
And what this is from the Special Medical Review Council. And this was a decision that was made by the Repatriation Medical Authority. And it's a statement of principles, which is actually a legal document. It's the legal legislative document. And what it says here, that it declares that there is sound medical and scientific evidence on which the RMA, which is the Repatriation Medical Authority, could have relied upon to amend the statement of principles to include the factors applying to chronic lymphatic leukemia as set out below. And they've stated there quite clearly non-ionising radiation. So what we have here is the federal government and the Medical Review Board, the Specialist Medical Review Board concerned under the Veteran Affairs Entitlements Act, have made it very, very clear that there is sound medical and scientific evidence in regards to factors applying to leukemia for example, its workers in the military as being affected by non-ionising radiation. So I hope that gives you a bit of an indication of what some of the liabilities and that some of the legislation that's out there.
Yeah. So
yes, employers. Sorry.
Okay, so in a court of law, if there were a dispute about is there evidence of risk, is there evidence that the worker could be harmed, then there clearly is. There are documents and statements and guidelines that suggest that this radiation is a risk. Yeah.
Exactly. And the issue that we've got is that you've got a federal government body, but then you've got other government bodies which are doctors. And just to give an idea, the APANZA is not a health organisation. It is not run by doctors at all. And you'll find that the Specialist Medical Board, for example, the International Classification for Diseases in regards to adverse health effects in regards to exposure, there's no limits set in the exposure standards in the World Health Organisation's ICD-10. But yet they seem to have done it with the APANZA standard. So there is a huge conflict. Now, the issue here is that which one prevails. Now, the APANZA makes it very clear that they don't offer health advice, and they even give a disclaimer saying that that anything that anyone has any health concerns or anything like that in regards to emissions, they go and see a medical practitioner. And that's exactly what shows that, in essence, the APANZA standard is obsolete when you compare it to medical advice. That's it. It's nice and simple.
And the APANZA standard also has a disclaimer now, doesn't it? So does that reduce
Yes.
the strength of that document, do you think?
Well, what it does is it strengthens the position of medical advice. So you'll find that science is a very unstable area. Science is all about collating things, and you'll find that there's always uncertainty in science. There is never an absolute in science. Doctors, however, treat their own patients. They are absolute. So they actually look at all the science, they interpret it, and they work out how to treat the patients based on that science. So when there's a lack of scientific certainty, so there's no certainty that EMR is safe. There certainly isn't. So therefore we have an uncertainty, and the law says it, and this is throughout the world, including Australia, that if there is a lack of scientific certainty, then the issue is that we must err on precaution. And the principle I like to use is, if in doubt, you kick it out. It's as simple as that. So that's how the courts see it. They see that the precautionary principle, it's embedded in Australian legislative policy, and we must err on caution. And that's exactly what the Workplace Health and Safety Acts are all about, because it says that the employer must make sure that the workplace is safe without risks. And we're talking about a risk. We're not actually talking about harm at the moment. We're talking about whether or not it poses a risk. And the World Health Organization has made that very, very clear, particularly in a school environment. If you with children, there's a risk. The Medical Repatriation Board, or Medical Specialist Board, there says that there is a risk for its workers in the military. So there are issues.
Yeah.
and employers need to be aware of it.
Yes, that's right.
And they're not, unfortunately.
Well, hopefully they will be after they listen to this.
Yes. Hopefully, yes. Yeah. So this is all about protecting the employer as well as the staff, and this is all, and I really appreciate, because what you're doing is really just educating, and I think that's really all this is about. If people aren't aware, and that they will fall into some serious legal traps in the future if they're not up to speed with what's going on, what's really happening in the litigation and the legal field in regards to this.
That's right. Thanks, Ray. And what's interesting is that there's already a legal precedent in Australia, because a few years ago, an Australian scientist called Dr. David McDonald set a legal precedent because he sued Comcare for symptoms that he developed at work as a result of being exposed to just everyday computers and equipment like that, the sort of equipment that most people would be exposed to.
Mm-hmm.
Now, he spent about 7 years in the courts, but eventually in the Victorian Administrative Appeals Tribunal, he was awarded compensation. So the fact that we have that precedent, do you think that is going to be helpful to other people in the future who might believe that they have some symptoms that they've developed as a result of exposure?
That case was an extremely groundbreaking case. That is the very first time that Australia has actually recognised, or the court system or the judicial system has actually recognised a person who has electromagnetic hypersensitivity and how that reacts. The issue was they didn't actually declare he had it, but he came down to the opinion that he had the belief that he had it, and that he had a rational belief that he was going to be harmed in the workplace. And that's what this is what this is all about. McDonald and Comcare, the scientist, Dr. McDonald, unfortunately he's passed away now based from his illness, but the issue is he was extremely sensitive to electromagnetic radiation, or so he said, in the workplace. He went and saw a doctor, and the doctor then did a medical report and basically said that in his opinion, Dr. McDonald, who his fears were real, the doctor believed that he was at risk of harm in the workplace. He then used studies to back up his theory. This is the doctor, and so there was a medical opinion given for Dr. McDonald. And when it went to the tribunal accepted the medical opinion over all the science that the other side put in. So in this case, the Australian government under Comcare threw in all the scientists from up Panza, from all over the place, to try and show that Dr. McDonald was not correct. But when it came down to the wire, the important thing with McDonald and Comcare is that the tribunal found that Dr. McDonald, in fact, his belief was rational. because he went and sought expert advice as to whether or not it was he felt that it was going to harm him, and that's how he was awarded the compensation. Not on the science. It was based on the medical opinion, and that's exactly what's going on with other matters today.
Right.
That makes sense. So it's a groundbreaking case, and I think you'll find that opened the doors for everyone, for lawyers to start to litigate against employers, against towers, against all sorts of things, and it opens up a huge can of worms for the workplace. I can assure you of that.
Well, yes, that's right, because if McDonald developed symptoms, or believed he just developed symptoms, that was years ago, from much less radiation than is in a typical workplace today. And then what are workers today being exposed to, and how might that be affecting them? And I know we can't answer those questions, but they're questions that may work their way through into court at some point. So based on all of that,
yes,
do you think that if a business says, look, I'll comply with the ARPANSA standard, and just to clarify, ARPANSA is the Australian Radiation Protection and Nuclear Safety Agency, which has set the radiation standard. Do you think that complying with that standard is all they need to do? Is that good enough to protect the employer?
Well, common sense says, okay, well, here we've got a regulatory authority that's been set up by the federal government by statute to provide advice, to advise, etc. You think there's a bit of a safe mentality that I find we just merely follow that, we're fine. But when you look at the standards themselves, you start to realise and unravel what's inside the standard, and a lot of employers don't actually read the thing. And particularly at the forward, which I use, or other lawyers would use to if they wanted to basically show the standards. If you're going to follow the standards, then you're not following them, because the standards say quite clearly right in the forward that if you're aware of a risk, this isn't a manufacturer, employer, or a user, or anybody that uses this substance, this electromagnetic radiation, if you're aware of a risk, then you're supposed to change your practices accordingly to that risk. So that's really what the ARPANSA standards are saying. Now, you'll find that if an employer is made aware of a risk, and they certainly say, well, I'm going to rely on the ARPANSA standards, then a lawyer will say, well, if you're following the standards, you're certainly not following them, because they made it very clear that if you're aware of a risk to health, you have to change your practices, and they haven't done that, and that's the issue. But the other thing is that the ARPANSA standards, there's also regulatory authorities such as the Telecommunications Act, and a lot of them say, well, we're just hiding behind the Telecommunications Act, et cetera, in regards to having antennas on our workplace and having towers put in our workplace where we're having an agreement with the telecommunications company to install a tower or whatever it might be. We're free from liability because of the issue with ARPANSA. We're merely following the standards. Well, I'm sorry to have to tell them and tell the workers that, the employers and the businesses that if you did something like that and just relied on the ARPANSA standards and failed to heed medical opinion, then you're at peril, and you're opening yourself up not only to civil liability but also criminal liability by doing that.
This is such an Sorry, Ray. We've got a bit of a time lag here, so sorry, I don't mean to talk over the top of you. But I just want to emphasise that point, because that seems so important to me, that my understanding and my interaction with a lot of businesses is they think that if they just have got the numbers right, as long as they're complying with that standard, they're protected. And what you're saying is something quite different, that they're not. They could still be facing legal action if they don't do something to protect their employees.
Yes, legal, both the criminal and in the civil sphere. And the other thing too, it's just because a council has approved a development or approved a tower or approved some sort of facility or approved some sort of, they're still, just because they're being passed by council, they're following the standards, does not protect them. No, as far as I can see in a legal sense.
Yeah. So what kind of ramifications do you think that might have? Can you give me some examples of what could happen to perhaps an employer, a business owner who doesn't look after?
Well, it comes down to I guess it comes down to an employer. If they're aware of a risk, and let's say an employer turns up and says, excuse me, I'm having some real troubles. I feel, and let's face it, an employee will simply say, hey, look, I don't feel well. They have obligations. If somebody comes up to an employer and says, excuse me, I've got an issue with my computer or the router or something like that, and that becomes an incident. And it's a reportable incident, and they should report that. Now, if they fail to report that, and there's also all other issues, and if there's been emails and plenty of communication between the employee and the employer, and the employer does nothing about it, then we've got some issues. Now, particularly if that employee presents a medical certificate to the employer, and the employer does nothing and doesn't heed it, then we've got all sorts of issues. Now, one would be that, and a good example would be, let's say, for example, an employee says, look, I'm suffering from this exposure. Please do something about it. A medical report's provided saying that the doctor believes that their concerns are real. Then there are issues there where if the employer doesn't do anything about it, doesn't listen to the medical advice, then anxiety issues, depression, those sorts of things can be sued for. And so you'll find that when they talk about is there any personal injury involved in this, and it's very hard to determine whether or not somebody is being harmed by electromagnetic radiation, but it comes down to their reasonable belief, their rational belief that it is. Now, if they don't listen to that rational belief backed up by medical opinion, then in essence they're opening themselves up to their employee suffering from depression, post-traumatic stress. There's all sorts of issues, and that's where that opens the door for an employee to sue. There are also criminal issues because I don't know if your businesses are aware of it, but the criminal code makes it an offence, and I'll just explain this very clearly, that anybody that applies force against another person without their consent constitutes an assault, and that's throughout the whole country. That's everywhere. Now, the definition of applied force is the most critical point. Applied force means applying electricity, or it can be electromagnetic energy, it can be, or any other substance or thing. So non-ionising electromagnetic radiation or microwaves or RF or radio frequency waves, whatever you like to call it, that technically it's an offence under the criminal code. If an employee comes up to you and says, I don't want this to hit me as an employee, they've in effect taken away their consent, and you're in essence, by allowing them to be irradiated, committing an assault. So there are criminal issues that can apply as well. It's a very scary area, and a lot of businesses and employers are just not aware of this.
No, that's right.
I can tell you now, the workers are.
And they now will be, hopefully. But this could apply to quite a few people too, because I'm thinking that the risks aren't just for business owners, but could the risk also apply to business managers or workplace safety staff?
Yeah.
Could they be legally liable if they don't do something to help their staff?
Yes. There is a thing in some states, and it depends on the state, but you have to go and see a lawyer about this, and so as you understand your liability issues and your risk issues. But if you're aware of a risk and you fail to address it, and you could be in what we call a joint. Let's look at the assault for a moment.
Yes.
We have what we call an unlawful common purpose, and the unlawful common purpose here is the end result is to irradiate someone with non-ionising electromagnetic radiation. That technically is an assault. So anybody that's involved in that, from the director of the company to the employees, etc., and they don't necessarily have to be aware of it, but they're part of that assault process, that they've approved it, for example, to go into the company. There's all sorts of things. Well, then they are all liable, all of them, and that's the reality. And that's it. And that's just the tip of the iceberg.
This is a huge issue. Do you foresee this issue ending up in court?
Oh yes, you have. Yes, and there's it's already going on now. You'll find that a good example would be restraint orders. So a good example, if someone's threatening to assault you or they are assaulting you, you can apply to the courts to have a restraint order put on them, such as a peace and behaviour order or an apprehended personal violence order, those sorts of things. You can actually apply to keep the peace, and those sorts of things can apply. And so there are remedies out there for particularly people in their homes. But let's say you're in the workplace, you're being assaulted, you can simply put a restraint order against your employer to stop them from emitting. Yes. And if they haven't got their practices set up where they can have, they don't necessarily have, this is about wide power, wireless type arrangements, so Wi-Fi, etc. There are safer alternatives. You can hardwire, etc., Ethernet, and I think employers have, we're all into this new technology world, and it's great to have all this wireless technology, but they've got to understand the legal ramifications that can apply on their workers. To give you an idea, the medical reports I've got say that exposure to electromagnetic radiation poses an extreme risk of harm to health. Not a risk, but an extreme risk of harm to health. So these are the sort of medical statements that are provided. Yes. Yeah.
And that comes as no surprise to me, because I've been doing a lot of work on this for about 24 years now. But it's interesting when you look at the scientific literature, there are now thousands of studies that are showing harmful effects in the body of exposure to this radiation. So I think this is something that, for me, we really want to get across to people listening today. Thank you. So do you...
And this is the thing, there are thousands of them, and you need someone to interpret it. So that's what a doctor does. So you got thousands of studies. If I went into court just with the science, it wouldn't apply. I don't use the science. I just simply use medical reports, because it's the medic. So I don't bother with medical experts. Science experts. I don't bother with the science. Let the doctor do that. If that makes sense.
That's good to know. So far we've been talking about the wireless environment that's out there today, but as you know, that we're facing the onslaught of 5G. 5G is currently being rolled out, and if the telcos have their way, we're going to see a lot more 5G in and around our homes and businesses soon. So do you think that the problem is going to be exacerbated by 5G at all?
Very much so. We have to err on precaution, or not we, but as a lawyer, we look at the risk in the workplace, we look at the risk everywhere, and we say, well, there's clearly a risk. And the biggest risk that people should understand, employers and workplaces, is that they can't get insurance to cover for injury or damage caused by non-ionising electromagnetic radiation. And you'll see it quite clear. And Lloyd's of London refuse to underwrite those issues. So we have a problem, a big problem.
Well, that's right. And I think with 5G too, there are so many unanswered questions. There are so many things that we just don't know about it. So even, if we were to look at the radio frequency radiation that this technology emits, we simply don't know enough about the characteristics of the signal to know how it's going to affect people. So we're opening a can of worms, I think, with 5G. But what it does mean is that we're all exposed to more.
Yeah, there's a great article that you can find. It's a very good economist who's put out what we call it's from the Legal Executive Institute, which is basically put out to all of the pretty much lawyers Australia-wide and throughout the world, and just explaining about the great rollout. And it basically says, will 5G be a boon for lawyers? And here it is. And I can assure you that that's exactly what's going to be. Okay, I'm right at the precipice of it, but I can tell you now that they're saying that the 5G, particularly in corporate issues, is going to be a boon for lawyers.
Yes.
Where businesses are just not ready, they're not prepared, and they're ready for a huge litigation. They said that this is going to be the biggest thing that will ever hit the world litigation field ever. Bigger than asbestos, bigger than anything else. The tobacco industry, this is a huge issue.
Well, I think it's bigger than those other issues because smoking was confined to people who smoked and the people around them. But this radiation is affecting all of society, and certainly in most workplaces it's affecting the whole workplace.
Yeah. And this is something that they're admitting that an employee cannot run away from.
Yes.
And this is the issue. If someone's smoking, at least you can tell the smoker to run outside and have a cigarette, or don't smoke inside. But the issue here is, and the other thing is letting employees come to work with mobile phones. So that's another issue. So that also creates what we call vicarious liability for the employer by allowing that to occur, allowing those devices to come into the workplace. Yeah.
And what we find is that a lot of employers don't actually know much about these issues, so they don't really know how to protect their employee.
Well, they won't know until the employee makes a bit of a song and dance about it, and then they sort of ignore it. And then before they know it, somebody like well, quite clearly lawyers have been educated about this throughout the world, and this is Thomas Reuters that have done this, and it's the Legal Executive Institute. So we're all starting to become aware, and it just happened to be I've been aware for quite a while. A lot of people wait to catch up. But
That's right. Well, I suppose this is a good time for me to ask if people in business, if employees or employers feel that they need legal assistance, can they talk to you about this? You're probably the lawyer who's most familiar with this issue in Australia at the moment.
Yeah. I mean, of course, I'm very happy to do that, and it's just to give them an idea of what their legal responsibilities are, and not only that, to basically educate them and show them what options are available to their employees.
Yeah.
And not only the employees, I might add, it's visitors to the workplace.
Exactly.
So you're a retail outlet, for example. You're inviting people, customers to come into the shop. You've got any visitor that comes in. So it's not just there are public liability issues as well, and this is where the insurance issue comes into it.
Yeah.
So if somebody complains and comes to the workplace, and a good example, have you heard of the mosquito before, which is a device that some shops and businesses are using to deter teenagers and to deter them from mulling around at the front of their shop? Well, to be quite frank with you, those devices that emit electromagnetic radiation in the form of sonic waves, particularly in the 8 kilohertz up to the 17.5 kilohertz range, are designed to dispel use. And they even use them in parks. You'll find councils are using them in Cairns, for example, Western Australia, and they're actually using them to get rid of unwanted adults in parks, for example. Yeah. Well, that's clearly an assault, whichever way you want to look at it. And would public liability insurance cover those in businesses? And I'd say that in reality, the policies make it very clear that they won't be covered for those things.
Yeah, yeah. That's thank you, Ray. That's tremendous. I think this is probably a good time for me to thank you and to let you know that we'll put a link to your website on our webpage, so anybody who wants more information about this can come to you. And I'd like to thank you again and hope we talk soon.
Thank you very much, Lyn. Thank you.
Thank you.